Creating a last will and testament in California doesn't always have to be an expensive and difficult task. In fact, in many cases, it can be put together and legally executed without seeking legal advice. This may allow individuals to save hundreds of dollars while still legally documenting their after-death instructions. This video will cover the importance of wills and what happens when one isn't made, what's included in wills, some legal requirements in California, and how and where to create an official will. Let's begin. What is a will and why is it important? A last will and testament, simply known as a will, is an essential estate planning document used to detail how an individual wishes to distribute their property among beneficiaries after death. It's crucial for all adults to have a will, especially those in the later stages of life, in order to leave behind instructions on how their personal and real property will be dispersed between their loved ones and other heirs upon death. Now, in the event of death without a will in California, when no will is in place upon death, the state of California, through its probate process, will dictate how the deceased property is handled. The person who passed away will lose control of who inherits their property. Disputes between family members, loved ones, and other heirs inevitably arise when no instructions are left. This can lead to legal disputes in probate court regarding who gets what that can last for months. One can avoid all of this by creating a clear will and often without an expensive attorney required. One can avoid all of this by creating a clear will and often without an expensive attorney required. A person of sound mind can draft his or her will in California by including the following information on the document: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator as well as 2 witness signatures. And finally, let's review some legal requirements in California. Last will and testaments in California must be signed by the person to whom the will belongs, known as the testator, in the presence of at least 2 witnesses in order to be legally executed. These 2 individuals must be competent adults, and though optional, it's recommended that witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once the will is created and signed, the document will be legally binding. Multiple copies can be made and given to the executor of the will and another trusted individual for safekeeping. We're eForms, the biggest database of legal documents. We have created extensive last will and testament templates for California that are quick and easy to fill. Our software generates an official document after you select your desired will instructions. Click on the link below to begin creating your will. And don't forget to like and subscribe for more daily videos.